Good morning, everybody, and welcome to this next session. I'll shortly be handing over to Phil Tansley, who will be presenting to you this morning. Firstly, just a couple of reminders from me. Please do, if you want to watch in a larger viewing pane, hit the theatre mode button, and don't forget to ask questions for our speaker using the polls function. We will have some time for Q&A at the end of this session. So without further ado, I'd like to hand over to Philip, who will present to you now. Thank you.
Good morning, everyone. I'm Phil Tansley, and I'm the leader of the cyber incident response team at Shoosmiths. When I'm not dealing with cyber incidents, I deal with technology and privacy litigation, including follow-on claims arising from cyber incidents. And part of that includes, unfortunately, dealing with claims against directors. So what I want to look at today is how some of the cybersecurity issues that we're talking about at the conference can feed through to directors' liability if everything goes wrong, and also from a director or senior manager's point of view, the sort of issues that the regulators and courts will be looking at when they've decided whether you've done a proper job if the worst does come to the worst. So the next slide is not meant to be a sort of an exhaustive summary of the sort of issues you need to think about as directors, and it's not meant to be a terribly prescriptive description of what went wrong in each of the instances that I've shown in the right hand column. But what I did want to show on this is an example of how management decisions can feed through into legal liability, and in some cases they're regulatory fines and penalties, and in other cases they're litigation. So there are 5 baskets of things that can go wrong from a management perspective that I wanted to focus on, and these are the sorts of considerations that the courts and regulators will feel lie with the senior management of the company, rather than at an operational level, with perhaps the CISO or the technology team. The first one, as we're probably sort of painfully aware of, for instance, like Target and Marriott, is failure to carry out due diligence. And there are really 2 baskets of claims there. The first is where you're acquiring a legacy business, failure to carry out adequate due diligence, get adequate representations and warranties from the target or the vendor, and you acquire a legacy business that's got problems with its security. Loads of examples of that. So Experian, Yahoo, well-known, high-profile examples. The other basket of claims, and then you're looking at Target, and most recently, I suppose BA is quite a high-profile example, is failure to carry out due diligence on vendors. And often, as we've probably been talking about at other points today, you can spend as much time and effort as you like on your security infrastructure, but if you've got issues with your vendors and they're not up to the same standards that you'd expect yourself, then that can come back and bite you. The other issues are processes and controls. Obviously, people are human, they do make mistakes. You have configuration errors, you'll have more sort of workaday problems with employees, clicking on things they shouldn't click on, or being, the victims of spear phishing and other forms of fraud. From a management perspective, the important thing there that you're under an obligation to manage is not stopping human error, which is always going to happen, but it's ensuring that you've got processes and controls in place which are going to manage that risk. You're doing things like testing your systems, you're doing things like making sure that individuals who are, particularly those who are most exposed from fraud or create the highest risk of a cybersecurity incident, if they get the job wrong, they're fully trained and they've got written practices and procedures to follow. So if the worst happens, you can at least show that those procedures were in place and unfortunately you've been caught out, but you did a decent job of making sure that the business was properly managed and did acknowledge those threats and try and mitigate them. Investment and resources obviously is another significant issue. Particularly at the moment, we obviously all have finite budgets to spend on technology, cybersecurity, as well as running business as usual. But I think particular failures to invest in IT infrastructure is an emerging director's liability, and in particular that's cases where there's just either a clear failure to invest in technology and upgrade software, ensure that your systems are secure, but also things like taking management decisions to deprioritize certain areas of the IT estate, and perhaps to deprioritize. The T-Mobile example I have there was a management decision to deprioritize patching of certain areas of the IT estate, and it turned out that was how the hackers got in. Post-incident handling can attract some attention, and we've got high-profile examples like TalkTalk, who I think had a number of difficulties on the post-incident side and how they handled things. They got a big fine. They also reportedly lost almost 100,000 customers. And then finally, there's litigation risk. And that feeds into the categories above. But again, if the company ends up being investigated, then there are substantial fines and substantial third-party liabilities. And in some cases, that can affect the share price and lead to litigation against directors in larger companies. And in smaller companies, you have a number of well-known examples. I think most recently Bounty, they were hit with a large fine from the regulators, but what's less known is they also then faced a raft of consumer claims that followed on from that fine, and unfortunately the company ended up going into administration as a result, because they simply didn't have the resources or the cyber insurance in place to deal with those liabilities. So just moving on to the next slide. I don't expect everyone to read those quotes in detail, but I think it's fair if you look at the published material from both the regulators and other important bodies like the NCSC, who their guidance is often looked at when courts or regulators are assessing what the appropriate standards of care to be expected from management are. I mean, those statements repeat a lot of themes which flow through both the guidance and also the sort of themes in my talk today. Management, there is a liability to ensure proper procedures in place, but also there's a liability to ensure that the culture is right, and that there's a positive culture around cybersecurity. So, for example, if issues are identified, there's an open environment where people feel they can discuss what went wrong, or have an open debate about the balances between resourcing and carrying out all the steps we want to take to ensure that systems are sufficiently robust. And there's also, on the post-incident side, emphasis on making sure we don't just deal with the incident and manage the fallout and then go breathe a big sigh of relief and then move on to the next thing that's pressing in the business, but we make sure that a thorough lessons learned exercise is carried on, and that the lessons from the incident are really truly learned, and ideally that will prevent repetition in the future. But in the worst case, that is at least evidence to a regulator who's looking at what happened, that you're a responsible organisation who takes their responsibilities to shareholders, investors, data subjects, customers seriously, rather than just being someone who's, I think as you know, the quote from Elizabeth Denham at the top says, treats cybersecurity as a box ticking exercise. So going on to some of the heavier stuff about the legal landscape. I mean, as a director, what are your duties to the company, and why might this be relevant? I mean, the first thing to say for those of you who haven't come across directors' liability issues, you know, how does a cybersecurity incident feed through into a D&O claim? Well, I mean, there are really three main scenarios where, as a director, you might be facing personal liability. The first is obviously the traditional small company scenario, where, or family-owned company, where the directors fall out. You know, there's a large incident, a director you know, moves on voluntarily or you know, involuntarily, and the new management looks to pursue a claim against the director because, again, fairly or unfairly, they're blamed for the incident. The second category is claims where the company realizes that you know, it suffered a significant loss from the incident, and perhaps somewhat cynically realizes they have D&O insurance in place, and there's another asset there which the company can go after to try and maximize its recovery from the incident. So on the one hand, you know, generally as an advisor to directors, I would strongly advise, if you can afford it, that you have adequate D&O cover. Occasionally that can be counterproductive, because that then creates a pool of money that that the company may want to get its hands on. And that feeds into the third scenario, really, where if you're in a situation where you're actually put out of business by a cyber incident, or, you know, go into a pre-pack, for example, there are scenarios where the creditors can take control of the company and they may want to pursue claims against the directors for a variety of the reasons I've just mentioned, either because, you know, they feel that the directors really did drop the ball, because they see there's a significant asset there, whether it's an insurance policy, or because the directors might be personally wealthy. So the basis on which those claims can be brought are generally, the main one that we see in the UK are claims under the Companies Act 2006. As some of you may know, there are 7 general duties that directors owe to the company under the Companies Act, and the ones that we normally come across in a cybersecurity context are section 172, to promote the success of the company. That's a rather amorphous concept. It generally entails things like not acting in the interests of third-party companies, you know, if you have a commercial conflict, or not acting in a way that puts your own interests, perhaps as a shareholder, above those of the company. The one that gets the most attention, though, is section 174, and that's your duty to act with care, skill and diligence in your dealings with the company. It's a little bit different from it sounds rather similar, but it's a little bit different to the contractual or legal duties which people often own, in that it's a 2-stage test. There's an objective test, which requires you to act with the general knowledge, skill and experience to be reasonably expected of someone carrying out your functions. So that essentially means that you'll be judged by the skills of a reasonable director of a company of your size and complexity. So, you know, it's not a defense to say that you're out of your depth, but you know, neither are you expected to you know, exercise a special degree of skill that you know, you wouldn't normally be expected to have. And then the second leg of the test looks at the knowledge and skill that you actually have as a director. So in this context, you know, if you're sitting on the board and, you know, you are a CISO, or you've got other particular knowledge of cybersecurity, then you will be judged according to that experience, rather than just saying, well, I'm a cybersecurity expert, but I happen to be sitting on the board of a haulage company, so I should be judged, by the standard of the average haulage director. Other sources of liability, the contract of employment is often overlooked. So in the contract of employment, you might have slightly different standards of care to the company. Generally, that would just be a contractual obligation to act with reasonable skill and care. And as you can see from the test above, that might often be a lower standard of care and might give rise to different measures of damages. So things like loss of profits to the company might be recoverable in the contractual claim, but wouldn't necessarily be recoverable depending on various sort of legal issues that lawyers like me sort of enjoy poring over in a director's claim under the Companies Act. The other category of claims that a lot of people write a lot about are derivative claims. Now that's a claim where the shareholders essentially apply to the court to stand in the shoes of the company and bring a claim against the directors, or they bring a freestanding claim that the company or the actions of the directors have prejudiced their interest. And generally you'll see claims like that either in some of the high profile examples from the US I'm going to talk about in the moment, where you have large publicly traded companies and the incident has caused the share price to drop, or sometimes in more closely held companies where shareholder value has been destroyed in other ways. The other thing to bear in mind, although it's not proved to be a huge issue in the UK so far, is there is personal liability in some cases. Under section 198 of DPA, where the director has been shown to have essentially personally connived in a breach of the Data Protection Act, the requirements under UK GDPR, then that can, in principle, give rise to personal liability. Generally, we've not seen claims of that sort exercised or threatened extensively by the regulators here, but I think it's aimed generally at particularly egregious breaches of data regulations. So, sort of cold calling companies and companies that are essentially, deliberately misusing customer lists to distress or, in some cases, sort of mislead consumers. And there are other isolated examples of personal liability under various other regulations, which I've listed there. And, unless you're in one of those particular industries, in which case you're probably painfully aware of them, probably shouldn't hold us up for too long. What happens if one of these claims come in? I mean, the main thing to worry about is obviously civil damages. They can be quite extensive in principle, depending on the loss of the company. The claims of this sort are often difficult to bring home, but obviously the threat of a large, potentially multi-million-pound personal liability is something that causes a lot of sleepless nights. And even if the claims don't ultimately come home, the amounts in question are quite significant, and we've seen some significant claims in terms of legal costs, but also settlements by D&O insurers and personally by directors. There's also liability for fines. Personal fines generally we haven't seen huge amounts of. Again, there are some examples where directors have been personally implicated in wrongful conduct by the company. But the other area that you need to be mindful of, particularly post GDPR, is if the company has a significant fine which puts it out of business, then that might lead to the follow-on claims of the sort that I've just mentioned. Confiscation, again, if the director is personally liable for the conduct, well, personally responsible for the conduct in question, then assets can be confiscated even though they've been taken out of the company by the time the regulator comes knocking. And then we do see some cases where, again, in that sort of area where the regulator considers that the director has been culpable in a deliberate misuse of information, where the court or the regulator will press for disqualification of the director. And the sort of periods we've seen are, from sort of 6 months up to 2 or 3 years. I was going to talk briefly about the position internationally, and the main thing I wanted to talk about was the position in the US, because often, the US is an incredibly litigious society compared to the UK. But what we've seen again and again in the field of cybersecurity is the sort of things happening in the US are very closely monitored by lawyers over here, and often where the US leads, the UK will follow in some form. So, for example, years ago when I started in cybersecurity, I talk excitedly about how you might have collective actions over here arising from large data breaches, and nothing really happened for years. But over time, we've caught up with the US. Some may say in a good way, some may say not, in terms of larger regulatory fines, and also increasingly active claimant lawyers. So, the sort of people who were doing PPI, a couple of years ago, are now looking at data as one of the big new frontiers of collective action. And as I mentioned with the bounty example earlier, we are already seeing that go from 0 to 100 miles an hour, from being, what this time last year I might have been talking about as a theoretical risk, or one where we were seeing letters of claim from ambulance chasing firms, which we were able to bat off quite easily, now resulting in much larger and more sophisticated claims that are putting companies out of business. The well-publicized claims in the US are the management liability claims. Initially, there was a lot of excitement about these. You had very big claims against companies like Target and Wyndham. They didn't go anywhere, so everyone thought, well, maybe it's the lawyers over-egging things, and that they aren't going to result in litigation. But we've recently had large settlements by Yahoo. That was about $20 million. And there's another ongoing claim, LabCorp, where I think there's a view that may well lead to another large settlement. FTC and regulatory proceedings, they can often mount up. You have very large amounts of defense costs, very large settlements, and then, of course, there's consumer class actions. If I move very briefly on, just a couple of other examples, really. Germany, again, what you see is very few private actions, but increasingly robust regulators, and they're prepared to take action against directors as well as companies. Australia, again, quite a litigious society. And again, there aren't that many examples, but there's a lot of talk around director claims and shareholder class actions. And I think it's only a matter of time before we see claims in Oz arising from cyber incidents. So just to wrap up before we get on to question time, what can you do about minimizing director liability? I mean, there are a list of examples there that it's probably unnecessary for me to simply read out to you. I think the important thing I would say is that both courts and regulators, they don't look at individual errors. They're not concerned about whether an individual made a configuration error that no one could have found out about until there was an incident. They're not concerned that someone in accounts clicks on a link in an email that they shouldn't have done. What they're really looking for is the fact that the board has considered its duties and has followed those through as positively as they can, and has also documented it. So it's very important, for example, that if you're having those discussions at a management level, that that perhaps the balancing act, for example, that needs to be taken into account when you're deciding what funding to devote to cybersecurity is documented. and that, you know, if there's a positive culture, you know, that finds its way into your training material, your practices and procedures, through incident management plans. You know, you show that they're documented, you show that they're tested rather than being put in a drawer. And it's really those sorts of considerations, as well as, you know, I'd also say having adequate insurance in place in case the worst happens, that, you know, are important in minimizing those liabilities. Right, I've got a 5-minute warning, so if there are any questions, I'll be very happy to answer them before I finish.
I'm just going to unmute myself there. Thanks, Phil, for that presentation. That was great. We have had one question come in here, which hopefully you can answer. How can I understand the actual cyber risk in my business when I don't have an IT team?
That's a very tough one. I think what I would say is, with particularly small businesses, the standard of care will obviously be lower. But you know, there are a number of fairly sort of cost-effective to access, and you know, and fair, you know, relatively lower level cyber resources, like, you know, Cyber Essentials or the government's guidance, that I think you can do. You can do a lot to reduce your liability by just showing that you've had regard to that. So you know, showing that you've in your board minutes or your, you know, internal documentation, show that you've reviewed those considerations. You may not have been able to spend a lot of money on it given the size of your business, but really just, you know, showing you've thought about your cybersecurity posture. This is what you've done about it. You know, you've reviewed, you know, freely available government guidance on best practice, and, you know, you've checked that your own procedures meet that, or, you know, if you don't feel you can meet it because it, you know, you're a small company and there are resourcing issues or there are other considerations, just that you've thought about it and addressed it as a board, not that, you know, you've gone out and spent a huge amount of your budget on you know, getting a cybersecurity team or anything like that.
Fantastic, thank you. Another question's come in here, maybe a tricky one. How could you convince a traditional CEO or director to request a higher budget for its IT needs without sounding like a liability department?
Well, I think, you know, as a lawyer, I mean, I would say that, you know, I started in cybersecurity, as I mentioned earlier, years ago, and in those days, you know, you had a few enlightened, you know, technology directors or, you know, execs who, you know, they junked the Kool-Aid and they could see that this is going to be a big source of liability in the future. And I think, you know, what we found as time has gone on is those sort of theoretical risks have, you know, they've all come through. They've not just been lawyers or, you know, cybersecurity people trying to drum up business for themselves. And, you know, increasingly you know, everyone is a technology business, you know, to some extent. And that sort of traditional view of, oh, well, it's a limited issue over here, and it's, you know, it's to do with security in accounts, or it's to do with, you know, security for our website, but it's not something that affects the whole business. It is, you know, is becoming less and less tenable, and you just have to look at, you know, issues like bounty and, you know, the fines that are increasingly being doled out by the regulators. You know, these ambulance chasing firms, you know, jumping on every breach now, and sending the, you know, letters of claim out to you know, really feel that this is, you know, it's come out of the cybersecurity box, and it's really you know, an all-encompassing business issue nowadays.
Great, thank you. Well, that brings us just in time to end the session, so thanks very much for that. Thank you so much for a great presentation, also to the audience for being so engaged there. That was fantastic. It's time to wrap up the session, and we're moving on with a pace now. So in 5 minutes time, we have another presentation starting, as well as a panel discussion. So please head to the agenda to select your session. Thank you very much again, Phil.
Pleasure.